Yes, Mr. Wardell.
Moving on to ground 2, a number of these points I can take shortly. We say that there were a number of factual findings the judge made against TTL that she shouldn't have made. She did acknowledge in paragraph 13 of her judgment that the defendant's evidence was certainly not sufficiently strong enough to enable her to conclude that TTL's factual case is no more than fanciful. And at 72, she made it clear that she was assuming in TTL's favour that it would be able to establish the facts on which it relies at trial. But that wasn't the approach she adopted in practice, not in all respects. And we give 5 examples in our grounds, and I'll deal with each in turn. And there are a number of common threads between the examples we give. We say that each factual finding was an impermissible summary finding, and each impermissible summary finding had an effect on her decision, either alone or cumulatively. And the upshot is that without those factual findings, the judge could not fairly conclude that the case was bound to fail. And indeed, the fact that the learned judge did rely on impermissible findings of facts just highlights the proposition that it's wrong to conclude summarily that those duties, or the duties we rely on, don't exist, and that it should be await a full trial when one can get a clearer understanding about these networks and how they operate and who controls them, so that at that stage the appropriate findings should be made. I'll deal with grounds 2E first. This is from the judgment at paragraphs 105 to 106, and the reason I'm dealing with this first is because the point we say is so clear. And you'll find paragraph 105 sorry, I've just lost the reference. Find it in a second. At 162, thank you. Where she says this: in addition to the unlimited nature of the class to which the alleged duty would be owed, it's also worth emphasising its open-ended scope. Based on the pleaded case, the defendants would be obliged to investigate and address any claim that a person had lost their private keys or had them stolen. How they would go about that in practice, given the anonymity system, is wholly unclear. As discussed in relation to fiduciary duties, the declaratory relief would be on an in personam basis. It follows that even if relief against the defendants would depend on the declaration being obtained, would not provide protection against rival claimants from whom the defendants might be accused of having expropriated assets. It's far from obvious that defendants could take steps to protect themselves by insurance. Well, there was no evidence for the court about the ability to protect themselves or otherwise. And there's absolutely no proper basis for making any finding, even in phrasing it in the way that she did, that the defendant could not or might not be able to protect themselves by insurance. That would require expert evidence and possibly factual evidence. And indeed, the fact that the judge uses phraseology far from obvious shows the extent of her error. And she used that to justify the conclusion that this also strongly indicates that based on considerations of fairness, justice and reasonableness, no duty exists. Now, although this was in the context of duty of care, this reasoning was also relevant to her findings as to fiduciary duties on the question of risk. That's at paragraph 80. We don't need to go back to that. She then went on. Just
going back to paragraph 105.
Yes.
In the second sentence, she says, based on the pleaded case, the defendants would be obliged to investigate and address any claim that a person had lost their private keys or had them stolen.
That's not our case.
Where is that in the pleaded case?
It's not our case. I don't have all the pleads in my fingertips. It's not the way we put it. We said the question of ownership is one that should be resolved by the courts.
Well, that's by amendment. Oh, sorry, that's
Well,
that gets us into ground 6.
Yes.
I think that's
Well, no, I don't think it
addressed
does.
to the
Don't think it
unamended
does.
pleading.
I don't think it does, but I'll get people behind me to double check rather than mislead you, if I may. We already seek a declaration to ownership in our existing particulars of claim.
Yes.
We don't require the developers to investigate the question of ownership. We're asking the court to make declaration of ownership. So,
But you do. I'm taking you out of your turn slightly, but the existing pleading does say that the developers are already in breach.
yes,
Not.
because we are the owners, and they're saying that they are not going to comply with their duties, even if we prove ownership.
Well,
We're not
says-
saying that they're sorry.
I understand, but you say all it says is they are in breach in a renunciatory way, as it were,
Yes.
in that they have made clear now that they will not
Exactly.
comply if you are held to be the owners.
Yeah. But our pleaded case doesn't require them to investigate ownership, which is the answer to my Lord.
Yes, I mean, the duties you plead are in paragraph 45, unamended particulars, page 198 of the court bundle, and they are specific to you.
Yeah. Can I come back to the pleading? Forgive me.
Sorry, it was my fault.
No,
I've
no,
taken you out of
forgive
your
me.
turn.
Just that I've got certain time limits.
Yeah.
So she goes on at 106, where she says, in contrast, owners of digital assets are able to take some steps to protect themselves against the loss of private keys, for example, by keeping copies in different locations and possibly by insurance. First part we say is wrong in any case, because as our case, the owners run the risk of hacking even when taking sophisticated measures to protect their assets. Secondly, also wrong for the learned judge to raise the possibility of insurance being obtained by TTL and others. That's a matter for evidence. It's definitely not a matter for application for summary judgment or strikeout. So what do the respondents say about this? The original respondents say, paragraph 30 at core 8, page 111. They say that the judge was entitled to conclude that Bitcoin developers were unlikely to be able to obtain insurance based on the undisputed facts of the potential value of claims against them, if this case were to be decided in favour of TTL, was a matter of actuarial assessment unlimited, and the class of potential claimants was equally limitless. That's pure factual assertion, and indeed assertion as to actuarial assessments that would be made. We don't accept, for example, that the potential class is limitless, or that the potential value is limitless. Nor does TTL accept that this would mean that insurance could not be obtained. In any event, that's not a matter at this stage. As to the position of TTL, respondents say that Falk J was also entitled to conclude that Bitcoin owners were likely to be able to obtain insurance because the insured risk would not exhibit such features and indeed would be akin to an ordinary indemnity against loss of property. Again, this is a pure assertion about the state of the insurance market, not backed by any evidence at all. So one cannot rely on that to justify a conclusion that our case is fanciful. In his skeleton, my learned friend for D14, we don't need to look it up, paragraph 38, call 26, page 269, he asserts that the point was peripheral, but again, that's just assertion and wrong. This matter was dealt with at the heart of the judge's findings under the heading discussion. And then turn next to ground 2A, part of which we've already looked at. That's where the learned judge says that other users could be disadvantaged. And she gives 3 reasons for that. First of all, at paragraph 76 of her judgment at 156. Which makes the point we've already discussed about rival claimants. And can I go back just the question I was asked about, well, what happens post-declaratory relief here, there's a claim in Orange County. A personal representative obtaining a Ray Benjamin order here is then given a green light to distribute assets on the basis that the beneficiary can't be found. That doesn't stop a beneficiary in due course popping up in Orange County or elsewhere saying, I'm the real beneficiary, I have a claim. And that sort of possibility doesn't begin to answer the question of what duties are owed by the personal representatives, and by a parity of reasoning, same here. The second point she makes is at paragraph 79. At a general level, some users may not agree that the system change that allow digital assets to be accessed and controlled without the relevant private keys, contrary to their understanding of how the system is intended to operate according to their interests, even if made only following an order. And then she goes on at 83. As already indicated, I can see that any holder of digital assets will have certain expectations, for example, about the security of the network and private keys, the accuracy of the proof of work process, and indeed anonymity. Now, before the judge, the original respondents relied on nothing more than mere assertion in their witness evidence, which was contradicted by the evidence we put in. We don't need to go there this afternoon. They now base their opposition on the Bitcoin white paper, and they rely on sections 1 and 10 of the Bitcoin white paper. For your reference, skeleton argument for the original respondents is a paragraph 22 and D14 paragraph 31, core 8109 and core 26267 respectively. That shows the fallacy of their approach. They're effectively inviting this court to review an 8-page document about the technical working of Bitcoin, and ask the court to then reach factual findings about the basis of the Bitcoin system, and therefore about the expectations of participants. And that goes well beyond what's appropriate in a summary procedure. Precisely what's meant by the white paper may require expert evidence. In this regard, the views of Dr Wright, who wrote the white paper, should be or may be given some weight. Secondly, it will be a matter of evidence as to what the usual expectations and understandings of digital asset holders are. For example, evidence will be called from certain asset holders, and information from discussions online can be produced and will shed light on this. And it will likewise be a matter of evidence as to the extent to which they will be aware of the white paper, or consider the operation of the network to be prescribed by it. Nowhere in the white paper does it say that in TTL's situation it shouldn't have its assets returned to it. And our factual case will be at trial if we get there, is that ordinary users would expect developers to return access in the event of a hack and a loss of access to their property. And we also note that section 8 of the white paper refers to the networks being overpowered by an attacker. We can see that of the agreed authorities, tab 29, page 993. And under the heading Simplified Payment Verification, and under the diagram it said this: as such, the verification is reliable as long as honest nodes control the network, but is more vulnerable if the network is overpowered by an attacker. While network nodes can verify transactions themselves, the simplified method can be fooled by an attacker's fabricated transactions as long as the attacker can continue to overpower the network. One strategy to protect against this would be to accept alerts from network nodes when they detect an invalid block, prompting the user's software to download the full block and alert a transaction to confirm the inconsistency. Businesses that receive frequent payments will probably still want to run their own nodes for more independent security and quicker verification. And what I get out of this is no more than this. The white paper clearly envisages incorrect transactions being put right. So to the extent to which users were in fact relying on the white paper to inform their expectations, which, as I say, is clearly a matter of evidence and fact in due course, it appears that they would envisage incorrect transactions being corrected in due course. But the fundamental point is that no decision can possibly be made about this at this stage. As to the change being to the disadvantage of other users, there was no evidence of this at all. I'll come back to the irrelevance of a change disadvantaging a fraudster pretending to own the assets in a moment. But more fundamentally, there was nothing to suggest that any other user would be disadvantaged. On the contrary, all users would benefit from protection that would be given to their assets. And in passing, I just note that the original respondent's skeleton argument, at paragraph 24, seeks to argue a case that is not and never was being put, and so can be discounted. We've never sought to rely on D1 as an anchor defendant. Their skeleton argument seems to think that we've resolved from that, but we haven't. It's as simple as that. And we say on this that the findings as to expectation as to disadvantage were central to the judge's analysis. They were the key parts of the small section headed discussion, where she set out her conclusions as to fiduciary duties. And we say absolutely improper at this stage to draw any such conclusion about expectation, particularly when those expectations are contrary to TTL's case. The next impermissible factual finding at 2B, or our ground 2B, was that another claimant to the assets would necessarily be a participant of the networks, such that there would be a risk to the respondents. And we've already seen that at the judgment of paragraph 76. And we say that's wrong as a matter of fact. As a matter of fact, a rival claimant will not be a participant on the networks. It will be a fraudster pretending to own the assets. That person will not be the true owner, and so will not be a legitimate participant. The judge concluded that a rival claimant would have a legitimate complaint leading to risk. However, that was premised on the factual assumption that the rival claimant would be the true owner. That was, again, not a factual, that again was a factual finding and not permissible. Now, the D14 accepts skeleton paragraph 41, but this was an important part of the judge's reasoning. And at paragraph 42, he then says there are rival claimants. But that doesn't address the fact that the judge found that rival claimants, albeit illegitimate claimants, would be participants and would have legitimate complaints. And the original respondent's only answer to this is to take the pleading point about our current pleading and to say that the proposed amendment is hopeless as well. They don't actually deal with other claimants being necessarily a participant and the fact that the judge made a finding to that effect. Ground 2C is important. This ground relates to the judge's finding that owners don't entrust their digital assets to developers. And I get this in paragraph 73 of the judgment at page 155 of the core bundle. The judge says this: the foundation of TTL's case is the alleged imbalance of power combined with an entrustment of property to the defendant. However, whilst an imbalance of power together with vulnerability to abuse is often a feature of fiduciary relationships and may in broad terms be a rationale, it's not a defining characteristic and certainly not a sufficient condition. Further, and to the extent relevant, I don't think that Bitcoin owners can realistically be described as entrusting their property to a fluctuating and unidentified body of developers of the software, at least in the sense and to the extent claimed by TTL. That last observation, at least in the sense and to the extent claimed by TTL, was not explained. And it's not clear what the judge meant by that. TTL's position is simply that any individual acting as the developer of a network has ultimate control over the digital assets on that network whilst acting in that role, and that the owners of the digital assets entrust their assets to those developers, having the legitimate expectation that they will protect their property interests. And so we say there's absolutely no basis on which the judge could properly conclude that TTL did not have real prospects of establishing that they entrusted their assets to the developers. That's clearly very important because from this passage it's clear that the judge thought it was part of the foundation of TTL's case. Nor did the judge have any basis for finding that the developers would be unidentified, which he does in the penultimate line of 73. Our factual case is that they are identified and they are the individuals whom we've sued. And before Mrs. Justice Falk, there was very substantial evidence that the respondents did have the power alleged so that they could dictate who has control of the digital assets, how such access is achieved and how those assets could be used. And certainly our case on that could not be discounted on a summary basis. And there are numerous examples in the evidence. I don't propose to take you to any now. I hope I won't have to, but if I need to, I'll do so in reply just to make good that proposition. Now, the original respondents say the judge reached a legal, not a factual conclusion about this. You can get that from their skeleton argument, see tab 8, page 110, at paragraph 26. It's where they say what TTL complains of is a legal, not a factual conclusion, namely that it was not entrustment where Bitcoin software developers were fluctuating in an identified body. Now, there was no basis for that assertion. Entrustment was referred to at the judgment at paragraph 65b on page 154 in the section where the learned judge set out our submissions on the facts. And 65b is clearly a submission as to the facts. Owners of the digital assets have entrusted the care of their property to the defendants and are vulnerable to abuse by them. And the question of whether or not an asset is entrusted to another is clearly a matter of fact. And the judge in the section I've taken you to did not suggest she was reaching a legal conclusion about this. Still less that she set out a legal test and then purport to apply it. In contrast to the other respondents, D14 makes the argument at paragraph 37 of this skeleton, page 268 of tab 26. And in paragraph 37 he says this, about 8 lines in, after referring to Laan, and Kent. They say, on any view, owners cannot be said to entrust with their assets in the same sense the trustee is entrusted with the beneficiary's property. The most that might be said is that owners are vulnerable to developers departing from the original features of the Bitcoin system. That might conceivably import a duty to remain faithful to the white paper. But that only goes back to the factual issue as to what developers are supposed to do under the white paper and what the factual expectation of Bitcoin users is, Bitcoin owners is. And D14 is hereby effectively accepting that this is a matter of fact. The final factual finding to which we refer is ground 2D, which is the conclusion that digital asset owners are by definition anonymous. Now, we deal with this in paragraphs 30 to 31 of our skeleton, that's pages 66 to 67. We say that that was wrong as a matter of fact, but I'm not really sure where this point goes, and I don't propose to develop it beyond our skeleton argument this afternoon. The question of anonymity or not can't provide the answer to whether or not fiduciary duty is owed, which is why I say I don't really see where it goes, and it's why I'm not proposing to develop it orally. And so on ground 2, we say it is clear that the judge, despite saying she was going to proceed on the basis that all assumptions of fact were going to be made in favour of my clients. She did in fact make findings of fact contrary to TTL's factual position, and she relied on those findings to justify her conclusion that no fiduciary duty was owed. So that brings to an end my section on fiduciary duty. In short summary, I'd like to make a few observations. We are dealing with a global financial network or system which is not governed by any contract. That's not something the courts have had to grapple with before. It's an entirely new situation. The respondents say that despite controlling the network, and despite the owners of digital assets having no power in respect to the networks or over the developers, and despite the owners of digital assets being open to abuse, the developers owe no duties at all. We say they must be wrong about that. And if this court was any doubt about
do
that,
they say that? They say they don't owe the duties that you say they do.
they say they don't owe any duties to us.
Right.
That's their position. They may have slightly watered that down in their skeletons, but their position below is no duties owed at all. We are not fiduciaries, and we don't owe any other duties. If the court was any doubt about the submission that I've been making, I would invite you please to go back to both, first of all, Begum and then Vedanta in the Supreme Court. Begum made it clear in the judgment of Lord Justice Coulson that it's not generally appropriate to strike out a claim on assumed facts in an area of developing jurisprudence. That decisions as to novel points of law should be based on actual findings. Lord Briggs, paragraph 48 of Vedanta, well settled that difficult issues of law are best resolved once all the facts have been ascertained, rather than upon the necessarily abbreviated and hypothetical basis of pleadings or assumed facts. Now, this is important. If one assumes, it proceeds on the basis that it's clearly arguable that some fiduciary duties are owed, but then the question arises as to whether, on the second part of that test, it extends to carrying out what we say they need to carry out to protect our interests. It's impossible, we would submit, and we would put it this high. It's impossible to apply the second stage of that analysis without a careful and detailed understanding of how these networks work, how they're controlled, and how easy it is in practice for them to restore ownership. And you can test it this way. If it turns out that the court is satisfied that they are fiduciaries, and the circumstances are such that there is a theft, and the person who's lost his assets has a complete and unarguable proof of ownership, and it turns out the developers have very careful day-to-day control of the networks, for which they're paid handsomely, tens, if not hundreds of thousands of pounds. And if it also transpires that they could, by one touch of a switch, restore access or prevent the fraudsters getting away and running away with the assets. Is it really to be said in those circumstances, it's unarguable so as to be strikeable, that they can't be required to reinstate access? That's the case on fiduciary duty. And my Lord Justice Popplewell was looking for an analogy. We say the best answer to an attempt to find an analogy is it's a novel situation when one is dealing with a global financial system which isn't governed by contract. The court has not had to deal with this situation before. It's only arisen in the last few years. And it's very difficult to draw any sort of commercial analogy. So I was going to move on to the pleading point before finally ending with the duty of care.
So we're on to your ground 6, are we?
Thank you. Ground 6 is that the judge was wrong to refuse to allow TTL to rely on its proposed alternative case, albeit TTL's primary position is it's unnecessary for it to have to do so. I'll deal firstly with why there's no need to run an alternative case, before then referring to the alternative case contained in the draft amended particular claim, and I'll take you through them later and explain why TTL should be permitted to rely on that case. I will then also deal with the grounds raised in the respondent's notices to the effect that, contrary to the judge's finding, the alternative case has no real prospects of success because it relies on a quia timet injunction. In this regard, some further grounds are raised by D14 that go beyond the terms of his notice. I will, for completeness, deal with them too, but our position will be that those grounds aren't properly before the court. My lords may wonder why the amendment point is being argued at all. We see it as a point of little practical importance. The reason being that if TTL does have real prospects of success, but only in relation to the alternative case, and at this stage it's not permitted to rely on its alternative case, then TTL has confirmed that it will simply reissue the claim and seek permission to serve that reissued claim out of the jurisdiction. There's no limitation issue. Given the findings made already, there could be no basis for such an application being refused by the defendants, and there'd be no basis on which they could set that aside.
What would be the point?
What?
What would be the point?
Well, we say there's no point. We say that's why this is a completely arid debate. If this court is satisfied, one, that we can't rely on the existing pleading, two, fiduciary duties are owed, and therefore our claim is not strikeable on that basis, but three, we shouldn't be allowed to rely on the proposed amendment before you, then all that will happen is we'll reissue. And we'll have a perfectly valid claim. And there'll be no jurisdiction dispute. So, yes, there is no point to this debate. And
So, if you succeed, will you have to apply to amend, for permission to amend in any event?
no, we don't think so, but for reasons I shall develop as we go through this section. But all the point I'm trying to make at the moment,
I don't mean for the purposes of the appeal, I mean for the purposes of the action.
If you are satisfied that the only basis for bringing this claim is on the proposed amendment, we will have to make that amendment.
No, I'm not even posing that. Suppose that you succeed in full. Will you not need to have the amended pleading properly before the court at the trial, so that you can run both cases?
Yes, we would.
And will you need permission to do that?
Yeah.
Permission? Will you need permission to amend in order to do that?
I'm not sure whether we need to have permission before, if we amend before the defence. Can I just check that behind?
I wonder whether we can bottom that out, because it's really puzzling me at the moment why you're not making an application.
It's
if you need it.
CPR Part 17. You can amend at any time before service.
Yes.
After that, you need leave.
Yes, but it's been struck out at the moment. So I'm not sure what we can apply to amend, because there's no pleading before the court that can be amended.
What's been struck out?
Our claim.
Has it? No, you've
no,
been refused leave.
Service refused on the basis it's strikeable.
Well, on the basis there's no serious issue to be tried. But
Yeah.
that's all a debate on the basis of the current pleading.
Yeah. Anyway, my first point is arid. I'll come to whether I need to apply before you to amend when I get to that part of the analysis, if I may. But we say we don't need to apply to amend because the currently drafted claim is sufficient. But I also wanted to make the point clear to you that if we lost, but only on the question of amendment, you saying with no formal application before us, therefore we're not going to grant this appeal, but you have a properly arguable case on fiduciary duty, we would in those circumstances just reissue, start again. And all that would go to is a question of costs.
But what I'm not understanding is why you hold over us that is what you do, rather than saying, well, we can apply for permission now, please will you grant it?
Well,
if you say that there wouldn't be any legitimate objection to permission, I'm having real difficulty. Maybe I have a suspicious mind. I'm having real difficulty in seeing why you don't just make the application rather than threatening to go through the whole thing
Well,
again.
I'll make the application then. I mean, we took a view, perhaps it was over technical, but yes, if it helps, I'll make the application before you.
Well, it's up to you, Mr. Wardell, whether you make it or not. But,
Well, I will. With that encouragement, I will make it. And that evolves any arid debate, or involves the need to go through the process again.
And the application is to amend the particulars of claim as they are now pleaded in whatever tab it is.
It is. And I'll come to the draft amendment in a moment, if I may.
Yeah.
So I want to deal with our case that they're already in breach and that there was no need for an amendment. And
Well, if you're going to apply to amend, why do we need to go into whether there's a need for it? Unless the application is opposed.
well, if the application isn't opposed, you don't need to.
Right. Well, shall we find out?
Yes.
Let's assume, Mr. Ramsden, that the application is to amend in accordance with the draft that we all have. Is it opposed?
My lord, it is opposed because, and I'll be brief. For the reasons we set out under ground 6, the question of amendment of the pleading in such a fundamental way, we say, has to be assessed very carefully in a service out case, because the case my clients have had to meet is a very different one from the amended case. And can I illustrate that by one short point? I will be brief. My lord asked a question a moment ago in relation to paragraph 105 of the judgment, in which the judge had observed that it was the pleaded case that my clients would be obliged to investigate and address any claim that a person had lost their private keys or had them stolen. And my lord, not unreasonably, asked the question, well, where's that in the pleading? Well, we see it in the pleading, and it goes to the heart of the unfairness of what is now taking place, potentially to my clients. If we look at the pleading behind tab 7, and we go to paragraph 40, and this is the critical precursor to the whole basis of the claim, namely, you, the defendants, who are foreign defendants we wish to bring before this court, are being brought before this court because we have written to you, we have told you, not with the support of a court order, we simply told you in writing that we're the owner of this Bitcoin, we've told you to give it back to us, and you have refused, and you're therefore being sued for that. So there is an obligation, we say, to investigate, effectively self-adjudicate, and then comply with the demand, or you get sued. And that was a perfectly proper way for the judge to understand the case against my clients. And that is the case against my clients, unless and until amended. Now, they're not here, obviously, and we would need to consider that very carefully with them. But their position is they've been brought to this court, they have participated voluntarily at great inconvenience and expense in assisting the court to deal with this claim. And now they're faced with a very different claim from the critical premise we see in paragraph 40. And that raises some important and fundamental issues, not just in relation to whether the pleading is technically permissible, but in relation to the wider impact on costs, the effect on the original judgment, and wider questions of abuse. Because such a fundamental change in the case against them is something the court should be very wary of entertaining.
Right. All right. Well, thank you, Mr. Ramsden.
So the prejudice to your clients is, one, costs, two, that there's an argument on abuse. Is that an unfairly short summary?
It isn't, my lord. It isn't an unfair summary. And it is right for me to point out, fairness, that of course we do say, and we argue this under our ground 6, that even as reformulated, this doesn't work because we'd still be required to take a position in the proceedings.
That's a different point.
That's a different point. So we're still going to be sucked into these proceedings, but the position on the claim that the judge was required to adjudicate and did adjudicate is that we are in breach because we've been written to, we've refused to respond to that letter by investigating and adjudicating it. That's it.
So far as costs are concerned, is the alleged prejudice met by what would be the usual order for costs, the costs of and occasioned by the amendment to your clients?
Well, my lord, no, with respect, we would go much further, because we would say this is a fundamentally different case. Because what is now posited is a completely different type of cause of action, where we would join not necessarily as antagonists, but necessarily
I
parties.
suppose you're right about that.
Yeah.
I suppose you're right about that, and that they succeed before us only on the alternative basis.
Yes.
Then the kind of order I've mentioned would enable you to get your costs to date, wouldn't it?
If indeed that was the order, if it's costs to date.
Well, no, costs of and occasioned by the amendment, which would be the usual order.
Well, my lord, we would, the reasons I've indicated, go a little further than that, and I say a little further, significantly further, materially, and say, if they were only to succeed on a case they introduced before this court on appeal, then a proper exercise of the court's
Yeah,
wide
you would normally
discretion
get
on
all your
costs.
costs to date.
Yes, we would say all costs to date.
Yes, all I'm suggesting is that's no different on the facts.
Well, my lord, it may not be in practice, but it ought to be explicitly the case in protection of those foreign defendants who've been brought here by compulsion, as the foreign jurisdiction always requires. The protection of their interests is particularly important. So yes, cost is important.
Right. All right. Thank you. Yes, well, I think you better make your application, Mr. Wardell.
Yes. I think I need to start by explaining why the particular claim currently formulated are apt to entitle us to relief. And we say our primary case is an existing breach of duty by the respondents. We're not seeking to have the defendant investigate and ascertain ownership, despite what my learned friend has just said in the course of his oral submission. It's for that reason why the claim has always sought a declaration as to ownership. The original respondents say their skeleton is not really arguable that respondents are in current breach of duty because TTL has not obtained a court order declaring that it's the owner of the allegedly stolen Bitcoin. No explanation or elucidation is given for that assertion, and it's wrong. The duties of the developers are owed to the owner of the digital assets, and we claim to be the owner, and that's pleaded at paragraph 29 of the particulars. We also go on to plead at 40 that TTL sent pre-action letters and that all the respondents have failed to accept that they're subject to the duties contended for. They also not agreed to take the steps required. In other words, as a plea, the defendant's position is there no duty that would be owed regardless of ownership. And the plea in this particular claim is specifically put on the basis that duties are to be owed to a person when there are assets that are known to be owned by him. In other words, the basis of the claim is that the defendants all have stated that even were TTL to obtain a court order as to ownership, or otherwise to be indisputably the owner, they would refuse to take the steps requested. Therefore, they are in actual breach as a result of the refusal to accept their duties, because one, TTL is the owner, and there's a real prospect of success on that point at trial, as the judge found, which finding isn't challenged, and two, the respondents have made it clear that they will refuse to give effect to the duties, even in the event that there is no longer a dispute as to ownership. In our skeleton, we've given the example, it's paragraph 69.4, of a solicitor who has money in his client account. It may be unclear who is entitled to the money in that account, and the solicitor may be justified in obtaining a court order as to ownership. For example, a solicitor could bring a stakeholder application under Part 86 to determine whether A or B should be paid the money. However, if I claim a right to be paid the money in the client account and the solicitor says, regardless of ownership, I will refuse to return the money to you, or indeed to anyone else, it's apparent that there is a pre-existing breach of duty. And as we say in our skeleton, it's not uncommon for claims to involve issues of the identity of the true owner of an asset, and the existence of such an issue doesn't mean that no cause of action arises. If it were otherwise, you need to bring two separate actions, one to establish ownership, and another for the steps to be taken in relation to the owner. Another example may be in an action for delivery up. There the question is whether the person holding the goods is required to deliver them up to the proper owner. The person holding the goods might legitimately say he doesn't know who owns the goods. But if he says that come what may, he will refuse to hand them over, then he must be in breach. And there is a further reason why in any event, at least in certain respects, it cannot be contended that our presently pleaded case is not one of existing breach. Can we look at paragraph 53 of our particulars?
Could we look at paragraph 46 first? Because I am puzzled, I have to say. I understand the way you're describing the case could be put. But paragraph 46 is where we see your allegation of breach of duty. I'm in fact, the amended one, tab 7, at page 97, but we can see it in unamended form. In breach of duty, and notwithstanding the requests, each set of developers has failed to take any of the steps set out at paragraph 46,
Yes.
as well.
Yes?
I.e., failed to restore access to the assets.
Yes.
Well, that's a claim that they're in breach by not having now already restored access to the assets.
And if you go on at B, and have shown no willingness to reverse any fraudulent transfer if such a transfer were to take place. And if we can go on to 51...
Sorry, but...
Sorry.
Can we put a line through A, then? You no longer maintain that.
Yes. Well, it's wider at the end of the bit in parentheses, or even to take any steps in this regard. So there are steps we say they should be taken to protect those assets in the interim.
What? Where do you see that pleaded?
Well, I think it becomes clearer in 51 when we deal with duty of care, where the breaches include A and B. You say they're currently in breach in failing to put in place appropriate arrangements for access to and control of digital assets on the system, and then allowing an owner access to his assets, protecting against fraud in relation to such digital assets, and taking steps as to reverse fraudulent transactions. And we're saying this is a current breach, not an anticipated breach.
But a current breach to users of the network in general now.
Yes.
Not of a duty owed just to TTL.
Not just to TTL, users in general, including TTL.
So it's not a specific patch as a remedy, as it were.
No.
Some software system that prevents
that
enables owners to have restored to them access.
No, you're quite right.
In general.
Quite right. The obligation to restore access by a patch or a system change arises as at the date of declaration of ownership. But here we're alleging prior breaches. You ought to have your system set up so that protection can be given in the event of fraudulent hacking. And
That's in effect an allegation of what? Faulty product design? Is it?
Well, system design.
System design.
Yeah, effectively. But we say that's not something that looks to the future, it's something that's pleaded as to the present. And we're entitled to rely on that now. And because of that, can be no complaint that that the service out was improper, and we can amend.
So the faulty system design, that comes in under the common law duty, does it?
Yes,
That's
it
not a
does.
fiduciary.
No. Now, in any event, as the court, as I'm sure, is aware, we contended in the alternative that respondents will be in breach when the declaration is obtained and they refuse to comply with what we say is their obligation. And we made that clear at the hearing before Mrs. Justice Falk. The amendment, as you've seen, is now set out in the draft amended particulars of claim at paragraph 47. On page 97 of the call. I know the friend complains this is a radically different case. It's not. It's purely a question of timing. First claim as we are the owners, you are in breach for having failed to comply with the fiduciary duties. second alternative claim is you will be in breach once we obtain our declaration of ownership. There's no substantial difference between the two cases in terms of what the respondents need to investigate. And my learned friend's quite wrong when he says that they have to investigate ownership themselves. They can leave that to the court. And my learned friend says in their skeleton in paragraph 65 that it was their argument long before the hearing that our case was wrong to suggest there was an extant breach. That's simply not correct. The primary respondents didn't run the point in their skeleton argument. It was only raised by D15 and 16 for the first time in their skeleton argument immediately before the hearing. And in any case, there's no proper reason why TTL should not be allowed to rely on its alternative case without the need to make a formal amendment. And we say the judge fell into error in so deciding. So I make an application for formal amendment, but that is without prejudice to my prior contention that there is no need for a formal amendment, and the judge erred in concluding that there was such a need. And we rely very much on the NML Capital and Republic of Argentina case, where the Supreme Court overturned the long-established rule in Parker and Schuller, which prevented claimants from relying on new causes of action without reapplying for permission to serve out of the jurisdiction. You'll find that tab 19, second volume of the Agreed Authorities, page 663. Is where it starts. You can pick it up in the judgment of Lord Phillips at 672. And they were granted permission to serve out. Argentina applied to set aside on the ground that it enjoyed state immunity. At the hearing of this application before Mr. Justice Blair, NML conceded that it could rely at first instance on neither of the grounds for alleging that Argentina did not enjoy immunity that had been advanced in support of the application to serve out. Indeed, ML sought to rely first on the provisions of section 31 and secondly on alternative provisions as to waiver and jurisdiction of the bonds themselves. And the court addressed Parker and Schuller at page 688, paragraph 68. And that was a decision whereby a claim had been brought for delivery up of goods. Instead, the claimants or the plaintiff then was sought to substitute it with a claim for deliver the relevant documents. But that rule was overturned, as you'll see from paragraph 74 on page 690. At the end of 73, 3 lines, Mr. Sumption sought to persuade the court to distinguish Parker and Schuller, but at the same time he invited this court to hold there was no longer any justification for following that decision, if indeed there ever was. I believe that Mr. Sumption is correct. Procedural rules should be the servant, not the master of the rule of the law. Lord Wolfe, by his reports on access to justice brought about a sea change in the attitude of the court to such rules, this included the adoption of their overriding objective with which the new CPR begins. CPR Rule 11 states the overriding objective of the rules is to enable the court to deal with cases justly, and this involves saving expense and ensuring that cases are dealt with expeditiously. When an application is made to amend a pleading, the normal approach is to grant permission to do so, where to do so will cause no prejudice to the other party, but that cannot be dealt with by an appropriate order for costs. This is cause the overriding objective, where all that a refusal of permission will achieve is additional cost and delay. The case for permitting the amendment is even stronger. I can see no reason in principle why similar considerations should not apply when an application is made for permission to serve process out of the jurisdiction. It is of course highly desirable that care should be taken before serving the process on a person who is not within the jurisdiction. But if this is done on a false basis in circumstances where there is a valid basis for subjecting him to the jurisdiction, it's not obvious why it should be mandatory for the claimant to be required to start all over again, rather than the court should have a discretion as to the order that will be best served by the overriding objective. And the conclusions at paragraph 78 over the page, where he holds that the rule in part should no longer be applied. The same approach should be taken to an application to amend a pleading that's been served out of jurisdiction as is adopted to any other application to amend a pleading. So the only question is whether there's a valid basis for subjecting the defendant to the jurisdiction and whether the only prejudice can be compensated in costs.
Well, that's a powerful authority in favour of giving you leave to amend your particular claim. It's no authority for saying you don't need leave.
I don't think there was an application to amend before the court, as far as I read the authority.
Well, the discussion is all about amendments to statements of case.
I agree.
And I think Mr. Justice Blair permitted an amendment.
Can I come back to that just to double check? I'm going to take just two other cases where there was no need for a formal amendment before the court. And the judge referred to a quanta in paragraph in a judgment of paragraphs 118 to 119. Just for your note, you don't. I wasn't going to take you to what Lord Mance and Lord Collins said, but just for your note, it's paragraphs 83, 99, 134, and 137. And if we can go on to a quanta, which you find as additional authorities 1, tab 1 that is, and we look at paragraph 49 on page 28 of that case. CPR 607 no longer requires us to the old order 11.
Which paragraph were you looking at?
49, my lord.
49?
Yeah. The application must be supported by written evidence. Now, rather, the application for permission must set out the relevant material, including a statement of the claimant's belief that the claim has a reasonable prospect of success. The notes give guidance to how the evidence may be given. I don't rule out that it may sometimes be convenient and appropriate for matters such as the identification of the ground in paragraph 3.1 of the practice direction upon which reliance is placed to be clarified or supplemented in the skeleton argument placed before the judge on the ex parte application. It's not best practice. The formal material ought ideally to be found in one place, which can always be amended if an issue is defective. It goes without saying, the identification of causes of action, their corresponding gateways, should be explicit. Identification by implication is not enough. And so it follows that insofar as the claimant wishes to rely upon the causes of action pleaded in paragraph 110 of the points of claim, doesn't have yet have permission to pursue those claims against parties served out of jurisdiction, and it's accepted the submission to service doesn't extend to these claims. So we say the question is whether the material is formally before the court. And if we go on to paragraph 51, see
Sorry, is that what 49 says? 49 is talking about the gateways and reasonable prospect of success.
Yes.
Well, you wouldn't normally plead the gateways as part of your cause of action.
No, but if you see that what Mr. Toledano was seeking in paragraph 51, he was applying to the court to rely on a limited implied contract claim, and the objection was taken at 52 over page. The bottom of the page, that the objection was taken, it should have been raised at first instance, and it wasn't. And he also objected that D1 to 4 were placed at a disadvantage, as they hadn't hitherto had cause to investigate the circumstances of the case with an eye to their impact on the proper law of implied contractual obligations. Despite all this, it was said at paragraph 54, it said that defendants weren't disadvantaged. Don't consider that the D1 and D4 were prejudiced in the manner suggested. For my part, I would regard as virtually axiomatic that the absence of some very unusual feature and implied indemnity here relied on will be governed by the same laws the contract the entering into of which generated the indemnity at any rate where the requested contract remains an express choice of law. And the conclusion is, the bottom of that paragraph at F, subject therefore to the question whether England is shown to be the appropriate forum, I would permit service by allowance on D3 and a D4 out of the jurisdiction of the claim in implied contract.
Pleaded. That paragraph 110.
Get that? Then we can go on to Kim and Park, which wasn't mentioned in the judgment, but referred to the judgment, it wasn't referred to. We find that at tab 13, page 470. And at page 480, paragraph Paragraph 40, court held this. Where the court holds that there is a defect in the pleading, it's normal for the court to refrain from striking out that pleading unless the court has given the party concerned an opportunity of putting right the defect, provided there is reason to believe he'll be in a position to put the defect right. In paragraph 19 of his judgment, the master recorded the claimant had informed him that he already had witnesses, and then the claimant demonstrated this wasn't wishful thinking or bluff by submitting the statements he did. And then finally Breeze and Chief Constable which you find in Additional Authorities tab 5. We can pick it up at page 149. This is a strikeout claims or summary judgment. And you see at paragraph 27 there was a new argument. On the eve of the hearing, the claimants raised a new argument which is addressed in a supplemental skeleton, responded to by another supplemental skeleton. That's that a person ought not to be entitled to take advantage of their own wrong, and that where a company such as CPH is rendered unable to sue for its loss, then Johnson Gould may be distinguished. And then at paragraph 35 on page 151, I was urged by the claimant's leading counsel to allow an application to amend if such would be required to permit a Giles and Ryan argument to be heard. I have no doubt the present pleading doesn't fully lay the groundwork for Giles and Ryan arguments. An example of how courts approach a situation where a pleading is deficient, I would refer to Kim and Park and Spencer and Barclays. And then he goes on at 37, it seems to me the decision whether to take a strict approach and therefore to bring this aspect of the claim to an end is essentially discretionary. It must be exercised rationally. Then at 38, he says that although not all requirements for Giles and Ryan argument are pleaded, in my judgment there's requirements, etc., etc. Some of the factual groundwork is there. It's pleaded that the defendant's officers knew that the prolonged prosecution and investigation of the claimant would cause the business to fail. And then his conclusion at 39, he makes an unless order at the top of page 153, unless by a date to be determined the claimants apply to amend their particular claim, if so advised to plead reliance on the principles in Giles and Ryan, it will be struck out. So
I'm missing something, Mr. Wardell. That says you should have the opportunity to apply to amend.
yes,
It doesn't say you don't need to amend.
no.
So where none of the cases you have yet shown us say you don't need to amend. They're all talking about
I don't think I'm
application.
doing very well on this one, am I?
They're all about applications.
I understand. But it does go to what the learned judge should have done when dealing with it below. If there's material before it below that justifies an amendment, she should have dealt with it. She shouldn't have just said, the claim is unarguable, therefore I strike it.
Well, that's a slightly different point.
Well, I think, well, probably wasn't making it very clearly. It goes back to the rules should be the servant, not the master of law. We made it perfectly clear below what our alternative case was, and the answer should not just have been, there's no formal application before me. The learned judge should have addressed that alternative case on the merits. If satisfied that alternative case on the merits, she should have said, yes, I'm not going to set aside service as long as you amend your pleading so as to be consistent with the submissions you've addressed before me. That's what I very inelegantly, clearly was trying to explain.
Right, I understand that point.
That's the point. And then the next question is whether or not our alternative case has legs. In other words, to put it vulgarly, is that also susceptible to being criticised? And this goes to the question of quia temet injunction. And the judge referred at paragraph 116 to our argument that injunctive relief, primary relief, is available on a quia temet basis. That's set out in Clark and Lindsall, tab 27, volume 2 of the Agreed Authorities Bundle, page 982. In addition to the remedy by action for damages in respect of torts which have actually been committed, there are in certain cases a remedy by way of injunction to prevent the commission of torts which are threatened or anticipated when cases of continuing injuries to restrain their continuance. And then at 2802, injunctions in second line may be granted in all cases in which it appears to the court to be just or convenient to do so. These words don't confer an arbitrary discretion on the court. Their effect is to enable the court to grant such injunctions as formerly could have been granted by courts of equity. And we say there's absolutely no principled reason why a quia temet injunction would not be granted in respect of threatened negligent action or threatened breach of fiduciary duty. And we rely on Lord Upjohn's judgment in Redland, Brick and Morris, which is at Additional Authority, tab 9, at page 319. And you'll probably all remember that was a case that required the defendant to take steps to prevent his land slipping onto the claimant as a nuisance claim, and the injunction was set aside on appeal because of the width of the language, and which didn't tell the defendant precisely what it was he had to do. But none of that did not undermine the fact that there was power to grant such relief. And the judge did hold, which is important, so I'll ask you to read 666, that section on page 319 to yourselves. The judge did hold at paragraph 124 of the judgment, that's C13166. Which said, nevertheless, and assuming for the moment the case had been pleaded to reflect the point, I wouldn't have regarded this fact as being a sufficient basis by itself to justify setting aside the permission to serve out. The value of the Bitcoin and the difficulties that would be likely to be encountered in recovering it if it were transferred or dissipated indicates the gravity of harm could be very significant. Further, following a trial for which TTL was successful, it would obviously have established both its ownership and a breach of duty. So whilst damage might remain to be established, breach would not be entirely anticipatory. And the respondents rely on Vastant and persons unknown, which you find in tab 23 of the authorities bundle at page 868.
Do we need anything more than what the judge quoted at 121?
No, you don't. And we say the answers to those questions are plain. The defendants have made it clear they won't enact unless required by injunction. And we say if they're not required to so act, the harm would be grave and irreparable. Our case is that the hackers will or may run off with assets worth billions of pounds, and or that we will never be able to access our assets. And given them vast amounts involved, damages will never be an adequate remedy.
My fault, I'm afraid I'm just not really understanding this. You're not seeking any injunctive relief at the moment because of fear of a future breach. The relief you're claiming is that if and when the obligation arises by reason of the declaration of ownership, then the steps should then be taken by way of a mandatory injunction.
Yes.
I don't, I'm afraid, follow where queer time comes in. I'm sure it's my fault, I'm just confused.
Well, perhaps it's the wrong characterisation. We say if we establish ownership, we're entitled to relief. An injunction should be granted.
Yes. That's the alternative case.
Yes. Yeah, that's the alternative claim as pleaded.
You said the judge shouldn't have simply dismissed or set aside the permission to serve out because of the possibility of amendment, but she does consider that, doesn't she, at powers 124 and 125, and she said that well, she might have granted the permission, but you didn't ask for it.
Yes, but she failed to have proper regard to the ML and Argentina point. She should have said, I'm satisfied that the alternative way of putting the case is a proper one, and quite clearly it would be arid to strike it out and make you start again.
So she should have done what Master MacLeod did.
Yeah.
Made an order, unless you amend in accordance with the draft within 7 days, service will be set aside.
Yes, exactly that. Can you give me a moment? My lords, unless you want to ask me anything more about this issue, I'm going to go on to ground 5, bearing in mind the time.
I just wonder if you want to say anything more in relation to the opposition to the application to amend based on prejudice by reference to costs and or abuse.
Well, the only prejudice could be in costs. Since this argument we ran below, it wouldn't be appropriate to order us to pay all the costs of proceedings because the proceedings will still be extant. The question of what duties are owed and what circumstances will still have to be addressed. It's very difficult to see what additional costs they will have incurred or been thrown away as a result of the very small change to paragraph 47. And despite what my learned friend says about other prejudice, I just don't understand it, I'm afraid. He seemed to complain about having to investigate the issue of ownership, but he doesn't have to investigate the issue of ownership, and in any event, that's a substantive question that arises on the pleadings. It doesn't arise as a result of the amendment. The question is what prejudice has he suffered as a result of the application to amend, and it's impossible to see any prejudice. He knows perfectly well what arguments he faced below, and he knows perfectly well what arguments he's faced in this court.
Yeah.
There is no prejudice. And certainly no prejudice that can't be properly compensated in costs, and maybe in due course one might have to have a debate as to the extent of that compensation. But I don't think I need to hold this court up with dealing with such possibilities now. So, my lord, in the last 50 minutes or so, I want to deal with duty of care.
Yeah.
If
you fail on fiduciary duty, are you going to succeed on duty of care?
Almost certainly not. One's always reluctant to say no. I mean, duty of care depends fundamentally on an assumption of responsibility. Assumption of responsibility as taking on the role is absolutely at the centre of my arguments on fiduciary duty. But although I completely see the point, I was going to take you through our case that you understand, so that you understand it. As you've seen from the particulars of claim at paragraph 51, we claim that the respondents owe it and other owners of digital assets a duty of care in tort and performing their assumed role. And we say that a reasonable standard of care is met by the respondents, ensuring that the software they control allows owners to access and control their digital assets and not knowingly allow third parties who are not the owners to access and control those assets. And as is again apparent from the particular claim, we say that the scope of the duty covers a situation where a digital asset owner informs the respondents that its private key to access its assets has been deleted in a hack presumed stolen by third-party fraudsters, who are accordingly likely to be in a position to access and control and therefore misappropriate the owner's digital asset. In that situation, a failure by the respondents to ensure either that the software is amended so that it allows the owner to regain access to and control of his assets, or that the software already contains a function to reunite an owner with his assets in the event of a fraud, amounts to a breach. And I was going to deal first with the legal principles underpinning the proper analysis as whether or not a duty of care exists. We accept that this claim is properly characterised as one of pure economic loss, resulting from negligent performance of the service being the writing or dictating of the software underpinning the operation of the networks on which the digital assets owners' assets are recorded. And in Henderson and Merritt, the House of Lords extended the principle first established in Headley-Byrne that a person who made a negligent statement could owe a duty of care to a person who suffered financial loss through reliance upon the statements to cases of negligent performance of services. You'll find that in tab 7. We can pick it up in the judgment of Lord Gough at paragraph at page 213.
So sorry, I missed the reference.
Oh, it's the appellant's authorities, I'm told. I do apologise, it's tab 7, appellant's authorities.
Yes.
And at 213, Lord Gough says this. He identifies at C onwards that the governing principle of Headley-Byrne as being assumption of responsibility along with reliance by the claimant. And he goes on at 214. To make it clear at 181B, the question is objective. Where he says, furthermore, especially in a context concerned with liability which may arise under contract or in a situation equivalent to contract, it must be expected that an objective test will be applied when asking the question whether in a particular case responsibility should be held to have been assumed by the defendant to the plaintiff. Now, the judge's summary of legal principles can be found at paragraphs 85 to 90 of her judgment. But although she mentioned Henderson, we say that she failed to take sufficient account of the nature of the claim and failed consequently to adopt the right approach. And first of all, at 85, we say the judge failed to give a sufficient consideration to the detail of their lordship's speeches in the Commissioners of Customs and Excise and Barclays Bank case, where the court considered the test of tortious liability and negligence for pure financial loss in great detail. Instead, she's just referred to it shortly as saying the assumption of responsibility test is not a universal test. You get that from the last few lines of 86. And we say that's an oversimplification. So if we can look at the Barclays Bank case, which you find at Authorities Bundle 7. That's the Agreed Authorities Bundle 7, tab 7 at page 179. And at 190F, Lord Bingham observed that the assumption of responsibility test may be sufficient in certain situations, which we say describe the present case. He says these authorities yield many valuable insights, this is just below E, but they contain statements which cannot readily be reconciled. I intend no discourtesy to cancel and decline to embark on yet another exegesis of these well-known texts. I content myself at this stage with 5 general observations. First, there are cases in which one party can actually be said to assume responsibility for what is said or done to another. The paradigm situation being a relationship having all the indicia of contract safe consideration. Hedley Byrne would have been such a case, White and Jones and Henderson and Merritt, although the relationship is more remote, can be seen as analogous. Thus, like Coleman J, I think it's correct to regard an assumption of responsibility as a sufficient but not a necessary condition of liability. A first test which, if answered positively, may obviate the need for further inquiry. If answered negatively, further consideration is called for. And we say the situation between TTL and the respondents fits into this category of cases, as the respondents, through their control of the software underpinning the networks, are effectively providing a financial system for the benefit of owners of digital assets recorded on those networks, and receiving financial rewards from third parties for undertaking that role. Lord Bingham went on to observe that at 181, that the incremental approach is no more than a method of confirmation. And that's from paragraph 7. Fourthly, I incline to agree with the view expressed by Messrs. Mitchell in their article that the incremental test is of little value as a test in itself, and is only helpful when used in combination with a test or principle which identifies the legally significant features of a situation. The closer the facts of the case in issue to those of a case in which a duty of care has been held to exist, the readier a court will be on the approach of Brennan adopting Caparo to find there's been an assumption of responsibility or the proximity and policy conditions of the threefold test are satisfied. And at 193, paragraph 52, Lord Roger just recognised that the assumption responsibility test may be decisive Yes, below D, in any event, he says, as the words which I've quoted from his speech in Merit syndicates makes clear, Lord Gough himself recognised, although it may be decisive in many situations, the presence or absence of a voluntary assumption of responsibility doesn't necessarily provide the answer in all cases. And Lord Mance deals with the point at page 202. Sets out the 3 approaches in paragraph 82, and then at 83 he says this: all 3 approaches may often, though not inevitably, lead to the same result. Assumption of responsibility is on any view a core area of liability for economic loss. All 3 tests operate at a high level of abstraction. What matters is how, and by reference to what lower level factors they are to be interpreted in practice. And it goes on to deal with incrementalism at 84. I note that the House's support for this approach was given with reference to a passage in Brennan J's judgment in Sutherlandshire Council, where he was rejecting the House's approach in Ann's and Merton. And below F, incrementalism was therefore viewed as a corollary of the rejection, now controversial, of any generalised liability for negligently caused economic loss, rather than necessarily inconsistent with the development of novel categories of negligence. Having said that, caution and analogical reasoning are generally valuable accompaniments to judicial activity, and this is particularly true in the present area. Then at 93, that's paragraph 93 on page 205, he says, Lord Mount says this: review of authority confirms there's no single common denominator, even in cases of economic loss, by which liability may be determined. In my view, the threefold test of foreseeability, proximity, and fairness, justice, and reasonableness provides a convenient general framework, although it operates at a high level of abstraction. The concept of assumption of responsibility is particularly useful to the two core categories of case identified by Lord Brown, Wilkinson, and White and Jones, when it may effectively assume all aspects of the threefold approach. If all that's meant by voluntary assumption is a voluntary assumption of responsibility for a task rather than of liability towards the defendant, then questions of foreseeability, proximity, and fairness, reasonableness, and justice may become very relevant. And the last sentence of that paragraph says incrementalism operates as an important cross-check on any other approach. And oh, yes, I missed the quote at 92, I'm sorry,
Yes.
just below C.
On which page?
Same page,
Same page, just below C. Yeah.
yeah, where there was it was said that the explanation was that although the categories of cases of special relationship were not closed, the only two hitherto identified were one where there was a fiduciary relationship. And obviously I rely on that, if I'm right, in our analysis of fiduciary duties. Now, so we say, first of all, the judge failed to give him sufficient consideration to this approach and to the importance of assumption of responsibility as a result of taking on the task. And we also say the judge should not have relied, as she did at paragraph 85 of her judgment, at page 158, on cases such as Robinson and Poole Council, as displacing the dicta in the Barclays Bank case we've just been looking at. And the reason she shouldn't have done so is that Robinson and Poole were not pure economic loss cases. The duties claimed in each of those cases were to protect from physical or psychological harm. In Robinson, the question was whether police officers have a duty of care to passers-by when arresting a suspect that extends to not injuring passers-by. In Poole, it was whether a local authority owes persons it has placed in local authority housing a duty to protect them from harassment and abuse by third-party neighbours. Those situations lend themselves less to the assumption of responsibility analysis that suits quasi-contractual situations where the defendant is providing the claimant with a service, but where his doing so is not governed by contractual obligation. We also say, thirdly, on the first point, that the judge was wrong to place reliance on the Privy Council case of Davis and Radcliffe as emphasising the importance of the incremental approach in pure economic loss cases. And the reason why we say this is paragraph 86 of her judgment, is because Davis was decided before the Barclays Bank case and decided even before Henderson. So that's why we say she was wrong to place so much emphasis on the importance of incrementalism. And then the judge went on to rely in paragraphs 87 to 90 on a series of cases that all were all concerned with the absence of general duty to protect people or property from physical harm by third parties, or to protect people from psychological harm by third parties, and saying there's an absence of liability for omission. We say to that extent her reliance was misguided. That's because none of those cases support the proposition but there was no liability for omissions in pure no liability for omissions in pure economic loss cases. The courts have held that there can be liability for omissions in pure economic loss cases where the defendant has assumed responsibility for the provision of a service and that service wasn't provided to a reasonable standard. And provision of a service necessarily involves positive action, and reasonable provision of it could necessarily involve protecting a claimant from a third party. And I'll explain this briefly, a bit more fully. In Midland Bank Trust and Heck, Stubbs and Kemp, Mr. Justice Oliver held by reference to the speech of Lord Devlin Hedley Byrne that an assumption of responsibility by a defendant to a claimant to provide a service could give rise to liability for pure economic loss in respect of negligent omissions. And in that case, as I'm sure you can recall, the solicitor had assumed responsibility for certain of his client's affairs, then omitted to take a certain step in respect of those affairs in not protecting the option by registering it. And the extension of the Hedley-Byrne principle to omissions by Midland Trust was approved by Lord Gough in Henderson. If we could go back to that, additional authorities, tab 7, page 214. That's E to F. I wish to add in parenthesis that as Oliver J recognised in Midland Bank Trust, an assumption of responsibility by, for example, a professional man may give rise to liability in respect of...
So sorry, which page are we on?
I'm sorry, on page 214.
Thank you.
Between, starting just below E, or at E, I wish to add in parenthesis that as Oliver J recognised in Midland Bank, an assumption of responsibility by, for example, a professional man may give rise to liability in respect of negligent omissions as much as negligent acts of commission, as for example where a solicitor assumes responsibility for business on behalf of his client and omits to take a certain step, such as the service of a document. And we say the different treatment of liability of omission in cases involving an assumption of responsibility on the part of the defendant can also be seen in physical or psychological harm cases, in dicta in the case, in dicta in the authorities relied on by the judge. So, for example, I don't think we need to look it up, but in the Littlewoods case, at agreed authorities 22, page 822, then 853, at 272D to E, Lord Gough explained that the defendant could be held liable for omissions that led to a loss of property where there had been an assumption of responsibility by the defendant, in that case by a decorator left alone in a property, not to leave, duty bound not to leave it unsecured. And in Mitchell, perhaps we can look at this, tab 18, page 648. Lord Scott explained 39 to 40. Just we pick up 39 just below C. A legal duty to take positive steps to prevent harm or injury to another requires the presence of some feature additional to reasonable foreseeability. But a failure to do so is likely to result in the person in question suffering harm or injury. The Pharisee, both in England and Wales and in Scotland, would have been in breach of no more than a moral obligation. And in Robinson, as the judge noted at paragraph 90 of the judgment, Lord Reid stated that, we can find that at 13, page 159. You don't need to go to the authority. The central point is the law of negligence generally imposes duties not to cause harm to other people or their property. It doesn't generally impose duties to provide them with benefits. Duty to provide benefits are in general voluntarily undertaken rather than being imposed by the common law, and are typically within the domain of contract, promises and trust rather than tort. So we say that's very much this case. And the application of those principles to this case well, I've already outlined the facts, I don't need to go back to that. We say that the relationship between the respondents and TTL and other owners of the digital assets amounts to an assumption of responsibility that warrants the imposition of the duty of care contended for by TTL. That's a duty to prevent economic loss by ensuring that the software the respondents write and dictate allows owners to access and control their digital assets, not third-party fraudsters. And we say there is at least a real prospect of TTL establishing that duty at trial. And in that regard, the judge failed to justify what she says in paragraph 101 of her judgment, where she says she couldn't see how any assumption of responsibility by the respondents could arguably extend so as far as TTL requires. And she was wrong, we say, to rely in paragraph 102 for the decision of Davis in the Privy Council. That's Davis and Radcliffe. You find that at 219 tab 8 of the authorities. This is a case came before Henderson. It doesn't say, it's not good authority for the proposition that good authority for the proposition that defendants will rarely be liable for pure economic loss. And properly analysed, there was no liability in Davis because the defendants didn't have sufficient control over the management of the bank to be said to assume the requisite responsibility to the claimant. As you may recall, the people who were sued were a member of a supervisory finance board, not actually part of the management of the bank itself. Checking what I need you to look at. Yes, can we go back to page 219 of the same authority? This is the Davis and Radcliffe case. I should have drawn your attention to the passage between D and F. Lord Doff says this: a further consideration which militates the imposition of a duty of care on persons in the position of defendants in the present case, that's being sought to make them liable in negligence for damage caused to the plaintiff by the default of a third party, SIB. In the case of physical damage caused by the deliberate wrongdoing of a third party, such liability will only be imposed in limited classes of case, a matter which was recently explored in Smith and Littlewood. Here it suggests that such liability should be imposed for purely financial loss flowing from the negligence of a third party. It must be rare that any such liability will be imposed. In any event, it's difficult to see that in the present case the defendants possess sufficient control over the management of SIB to warrant the imposition of such liability. And here, it's unnecessary to apply the threefold test set out in Caparo because it's answered by the assumption of responsibility founded on a fiduciary relationship, as Lord Mance observed in Berkeley Bank. And again, as both Lord Mance and Lord Bingham noted in Berkeley Bank, the question of whether the duty contended for constitutes an incremental extension of the law of negligence by analogy to established categories is merely a cross-check that should not prevent the principal development of the law in novel circumstances. As we state in Underground F, dealt with at 67.5 of our skeleton, there's a real prospect of establishing that the claimed duty of care constitutes a permissible extension by analogy to the Quince-care duty established in Berkeley Bank and Quince-care. And as I'm sure the court knows, the rationale of Quince-care is this: where a bank has assumed responsibility for processing transactions involving money recorded on its system for the benefit of the owner of that money, it should provide that service with reasonable care and skill, and that extends to refusing to process transactions where it's put on inquiry the proposed transaction is for the benefit of a third-party fraudster rather than the owner of the money involved. And the rationale of the duty contended for here is similar. The respondents provide a service not so far removed from that of a bank. The software they control governs who can process transactions in respect of digital assets recorded on those networks, and therefore which transactions can be processed. The respondents have assumed responsibility for ensuring that transactions involving digital assets are processed for the benefit of the owners of those assets, and it doesn't matter there's no contractual relationship, demonstrating the assumption of responsibility between the bank and its customers. The fiduciary relationship between the respondents and the owners of the assets is sufficient. And as the original respondents noted at 63C of their skeleton argument, the Quince Care duty is founded on there being a fiduciary relationship between the bank as agent for the customer. And we say the respondents deliberately organise themselves so that the service they provide isn't offered through an umbrella or organisation, and there is no contract between them and users of the networks. And the respondents provide the service which they've assumed responsibility by allowing owners to access and control their digital assets and not knowingly allowing third-party fraudsters to do the same. Accordingly, where the respondents become aware that it's likely the third-party fraudster stole an owner's private key and could misappropriate that owner's digital assets, they fulfil their duty of care by amending the software they control to put the true owner back in control. As is obvious, and as was stated in its case itself, there are clear public policy reasons behind the Quince Care duty. And given the dicta in Midland Bank and Henderson, it's unsurprising that the Quince Care duty of processing transactions with reasonable care has been held to have an active element to it, requiring the bank to make reasonable inquiries to uncover any fraud. And that this is a position is now clear from the judgment of my Lord Justice Birss in Phillips and Barclay Bank case, which you find at tab 20 on page 729. And it's paragraph 28 here. The reasoning in these cases is quite simple. Starting point is correct identification of the relationship between the customer and the bank in the context of the instruction to pay. The answer is that the bank is the agent for the customer's principal. See Stain J and Quince Care. This is not in dispute. Next one asks a question about the state of affairs where the banker knew that the relevant instruction was an attempt to misappropriate funds. In such a case, the obvious answer was the bank which executed that instruction in those circumstances would be liable. NB, this question is posed irrespective of any question of constructive trusteeship. The issue is about whether the bank, which has a primary duty to execute a payment instruction and also a duty to exercise reasonable skill and care in and about executing the customer's orders, would be liable for breach of that latter duty. Once that second step, I want to H, is accepted, the final question is then, what lesser state of knowledge would put the bank under a legal obligation? The answer that was given by Stain in Quince Care and approved by Lord Justice May and Lipton and Gorman, and now expressed in singularis, is that if the circumstances were such that an ordinary prudent banker would be on inquiry, then the duty arises. The duty is not to execute the order while on inquiry and to make inquiries. The objective standards are expressed in different ways in different cases, but they're equivalent. The ordinary prudent banker, the reasonable bank manager, and the honest and reasonable banker are the same person. And similarly, we say the claim duty is at least arguable here, even though it requires the respondents to take positive steps of writing and or dictating updates to the software governing who can access digital assets recorded in the networks. So, my lords, finally, I turn now to what we say the judge's errors of analysis were in the duty of care, in her discussion of the duty of care. I've already set out our position in respect of ground A, where we say there's a real prospect for a special relationship existing between TTL and the respondents. by the reason of the respondent's assumption of responsibility to write and dictate software that allows owners to access and control their digital assets rather than third-party fraudsters. This is established by showing there's a real prospect of a fiduciary relationship between the respondents and TTL being found to exist. In respect to ground B, dealt with its paragraph 67 little 1 of our skeleton, that's C676. The judge was wrong to hold paragraph 105 of her judgment, which you find on page 162 of the call. Wrong to hold that the claim duty is open-ended in scope, and that on the pleaded case it requires the developers to investigate and address any claim that a person has lost their private keys or had them stolen. As I've explained in the context of fiduciary duties, the duty is owed to the true owners of digital assets only. The duty does not extend to investigating or ascertaining ownership, and that's a fundamental misconception on the judge's part wrapped up in her judgment. And that stems from the misplaced concern argued for by my learned friends about rival claimants. If there's reasonably a question mark over ownership, then, including any risk of off-chain transactions raised by D14, the respondents could require the courts to declare claimant to be an owner before they would act. In respect to ground C, that's 5C, dealt with at 67.2 of our skeleton, the judge repeated the same error at 105 of her judgment that she made in respect to fiduciary duties in holding the possibility of rival claimants to the ownership of assets is relevant. And I refer you to my previous submissions about that. And in respect to ground 5D, that's dealt with at 67.3 of our skeleton, we say the judge repeated the same error at paragraph 107 of her judgment that she made in respect to fiduciary duties in holding that the fluctuating identity of the developers in control of the networks is relevant to the question of whether the respondents owed the claim duty of care. And lastly, in respect to ground 5E, that's 67.4 of our skeleton, the judge was simply incorrect to hold at paragraph 104 that the potential class of claimants is unknown and potentially unlimited. The potential class of claimants is limited to the true owners, it's thus knowable. Again, we say the judge fell into error by looking at rivals, placed concerns about rival claimants, and we say it's analogous to banks owing a quince care duty of care only to those customers whose money is recorded in the bank systems. It's obvious that the banks owe no duty of care to fraudsters and those people trying to extract money from the true customers. And in Davis, which the judge referred to paragraph 104 of her judgment, the alleged duty was said to be owed to those who deposited money in the bank and to those who were simply considering whether to deposit their money with the bank. So, of course, the potential class of claimants was unlimited and unknowable. The duty of care TTL contends for is certainly not claimed to be owed to those who are thinking about purchasing digital assets recorded on the network. It's owed to the owners. In Barclays Bank, which the judge also referred to 104, Lord Mant said a factor that militated against the recognition of a duty of care in respect to economic loss is the indeterminacy of any resulting liability. But that's of no relevance to this case, where the liability would be limited to the value of digital assets held by the true owners and to the true owners only. So, my Lord, we say in the circumstances the judge should not have held that the TTL's case on the existence of a duty of care was fanciful. Got there in time, just. Unless I can help you any further, there are submissions.
Thank you, Mr. Wardell. Thank you very much. Yes, Mr. Ramsey.
My Lord, thank you. I'm not going to start where I had intended to start, and I hope that's for good reason, and I hope that it will also be of assistance to you, because what I want to do is two things in the time I have today before I reset overnight in light of the submissions today, is to deal firstly with where we see the critical claim on fiduciary duties is now sitting, and to address, whilst they're fresh in our minds, a number of important points which impinge on the question of fiduciary duty, and in particular, the question of whether, objectively assessed, they could arise in this case. And secondly, I'll return briefly to our ground 6 and the question of amendment in order to assist the court as much as I can with how it might sensibly and proportionately approach that question. We start logically in the consideration of fiduciary duties with whether the court really is being asked to develop the law in a complex and developing area, or whether, as we have said in paragraph 12 of our skeleton, that's core page 107, that this is really no more than the application of established principles to novel facts or novel technology. And if I may say so, my Lord Justice Lewison made that observation earlier. We agree that is a true characterization of this claim. If that is right, the court is entitled to be very cautious before accepting that this case should pass the jurisdiction threshold by virtue of importance, complexity, or novelty. And the point was reinforced in the course of submission this morning when my Lord Justice Popplewell asked Mr. Wardell, well, what is the point of law? And the answer to that question was not, in fact, a point of law, but the proposition that on the facts of this case, TTL passes muster in establishing fiduciary duties according to the established principles. What, however, are those established principles? We had essentially 3 formulations in the course of submission in answer to questions from my Lord. And it's important to refocus so we can frame our arguments on what those are now. The first and boldest was that imbalance of power is the rationale, to quote Mr. Wardell, for the existence of fiduciary duties. And on that, he relied upon hospital products. We will focus tomorrow on Churnside, which we think is a more apt and appropriate New Zealand authority. So imbalance of power is the rationale. He went on to say everything else is a mere characteristic of the duty which is so created. It was in answer to that proposition that my Lord Justice Lewison asked Mr. Wardell, well, what about the farmer? And that was rather brushed off, if I may say so, on the premise that that must involve a contract. The question was followed by my Lord Justice Popplewell, who asked, well, there must be circumstances where there is an imbalance of power, but no assumption of undivided loyalty or abnegation of self-interest, if we use Lady Arden's description, electi machi. Well, the farmer analogy, if I may say so, is a good analogy because big buyers of agricultural products can, of course, abuse their market position long before a contract comes into existence. Indeed, the abuse of their market position is likely to exist and be exercised before the contract is concluded, because the whole point of the abuse is to arrive at a contract that suits you. Exactly. No, I have some anecdotal experience of that. It's the way that the commodities market will actually work in this jurisdiction. It's a matter of public record, and it's the reason we have competition law. And the reason we have competition law to prevent market abuse of that kind is because fiduciary duties don't exist to assist the farmer or any other producer who happens to be trying to ply their commodities on the market. So where does pure imbalance of power operate in equity? Well, it operates under the doctrine of undue influence. Imbalance of power is quintessentially met by the doctrine of undue influence. If Mr. Wardell's boldest proposition were to be right as a matter of law, that doctrine would be all but odious. So we reject absolutely the notion that imbalance of power is the rationale. There was a revised formulation in answer to my Lord Justice Lewison a little later this morning, which was in these terms. A has entrusted property to B, which has resulted in an imbalance of power where A is at the mercy of B. Now, that of course, engages the entrustment of property test the judge inevitably, and we say perfectly properly addressed, because that was the way the case was in part put to her at first instance. So we edged closer to the proper formulation with that second proposition, but it was yet further refined this afternoon when, again, my Lord Justice Lewison asked Mr. Wardell whether, if he failed on his fiduciary duty case, he could succeed on his duty of care. And he answered, my Lord, in these terms, no, because I need an assumption of responsibility. Presumably meaning that if he fails on the assumption of responsibility under fiduciary duties, he can't possibly establish it as a matter of common law. So in a rather circuitous way, and via three different formulations, we seem to have arrived back, not in one bite, but in three different bites, with what is broadly the right test in this jurisdiction for the existence of a fiduciary duty. And we say that is the correct starting point from which we must proceed.
So how do you formulate it?
We say that the Lectimaki formulation by Lady Arden is the correct formulation. And, my Lord, we accept that there are a wide variety of circumstances where an assumption of responsibility, of undivided loyalty, the avoidance of conflict of interest, and the avoidance of causing harm might arise. We also accept that the abnegation of self-interest, properly characterized by Lady Arden, may not apply in all cases, but it would seem to us to be a necessary ingredient for fiduciary duties here. My Lord, I will show tomorrow morning why we say Churnside and Fay, which of course in the New Zealand Supreme Court considered hospital products. It is, when one looks at it fully, a correct and consistent application of those principles. And as it were, the dicta that flirted rather with the imbalance of power concept was no more than a reflection that that may be a factor that you would see in circumstances where there are the establishment of fiduciary duties. But it isn't, as Mr. Wardell sought to portray it, the rationale which on its own gets you home. We have a further difficulty in the formulation of TTL's case, which arose in the context of the amendment application. And that was the point that was drawn out during the exchange between Mr. Wardell and my Lord Justice Popplewell in relation to common law duties. Because unlike the fiduciary duty, which appears to be directed entirely at remedial acts, that is, remediating or ameliorating the position of TTL in response to the alleged hack, the common law duty is much wider, and it predates that duty. The common law duty is to ensure that the software originally issued by the code writers does not contain bugs or defects. And that's what prompted my Lord to observe it's a sort of quasi-product liability obligation. You need to make sure your software's in its original form prior to any mishap or wrongdoing is in proper form. And that, for my Lord's note, is in paragraphs 51 and 52 of the POC. That's core tab 7, pages 98 and 99. That leads to this additional difficulty in respect to the way the case is now put, and it's a very unusual one. The common law duties asserted, which a moment ago were conceded as being essentially parasitic or dependent on the establishment of fiduciary duties, are, if they are to be permitted, wider, more expansive than fiduciary duties. That is, we say, conceptually, a very surprising proposition at the least. We say it is completely offensive to any kind of principle, because fiduciary duties would ordinarily be regarded as much more onerous than mere common law duties. But whether that's right or not, that is, we say, another significant problem we now confront in analysing and accepting that these duties exist. In the same vein, and when we look both at the objective analysis necessary for the establishment of fiduciary duties and the closely associated policy reasons asserted in support of ground 1, there is a further important factor to bear in mind. And that is, we say, that this whole case is predicated on a false dichotomy. That false dichotomy is that if TTL is not entitled to the relief it seeks in this claim, and in the manner it has pleaded it, whether primarily or by amendment, it has no remedy. We say that that is simply not the case. My Lord Justice Birss may be forgiven for having forgotten, but a long time ago in September 2018, my Lord granted what is generally regarded as probably the first freezing, disclosure and delivery up order over crypto assets. And indeed it was Bitcoin in a case called Vorat, Senator and Nebius. And since then, the judges of the Commercial Court in London and the business list have been at the forefront, as they so often have, of developing this area of the law to aid parties who have been wrongly deprived of their crypto assets, including, both before the Commercial Court, the business list, and in common law jurisdictions such as the Cayman Islands, injunctions against persons unknown to freeze crypto assets pending an orderly investigation into their status and eventually their recovery.
Against whom is the delivery up order made?
In that case, there was an identified defendant. In a persons unknown case, of course, one is confined to the injunctive relief. But the persons unknown jurisdiction...
Well, what practical use is it?
Well, it stops the movement of crypto assets.
We serve it on the controllers of the network.
You do. You do.
I can see that. So, in assuming that TTL's facts are right, the freezing order would be served on your clients. As controllers of the network, they could freeze anything that happens from this particular account, presumably. But can they deliver up?
They can't, but the wallet in the wallet where this crypto is held is identifiable. So unusually for a fraud, an alleged fraud, everybody knows where this crypto is, hasn't moved.
Yeah.
And various reasons for that have been posited. From there's an algorithmic masking of.
No, I follow.
You see that, but
I do.
But
Mr. Wardell says, I want to get my hands on this asset, and I can see that the freezing order will stop anybody else getting their hands on it. But how does TTL turn it to account unless it can get into the wallet? And does the freezing and delivery up order achieve that?
Well, my lord, this isn't wholly anecdotal because it is what has happened in other cases. But where a freezing order has been obtained over a wallet, someone has the algorithmic key to that wallet. Once that wallet is secured and it cannot be transacted, the claiming party then has the ability to interrogate software, those who've had any connection with the transactions on the blockchain, platforms who may have dealt with that Bitcoin in the past, in order to identify who or what is controlling it. And although anonymity is in many respects at the heart of this technology, it is nearly always possible, I can't say in every case, but nearly always possible, to find the identity of the controller of an electronic wallet, because at some point they will have interacted with the world outside the blockchain system. And again, not just anecdotally, in cases that has been done in very mundane ways by seizing or obtaining disclosure of SMS messages, WhatsApp messages, wire messages, all sorts of ways of sending instructions or receiving information in relation to that wallet. In this case, that would ordinarily be done by investigating the hack to establish through tracing of the means by which that hack was carried out, those who were behind it. Now, my lord...
I'm sorry, really sorry to interrupt you.
That's all.
I don't understand something you said quite early on in answer to a question from my lord. Forgive me if you'll tell me that I did it, but I don't recall freezing order being served on your clients. It's not your clients at all.
No, not at all, not at all.
That's fundamental.
No.
Everything you said isn't about your clients.
No, my lord, you're quite right, but in circumstances where a freezing order, in that case, in Birss and Avon, served on an identified defendant who was alleged to have misappropriated Bitcoin in what was an FX exchange, if my lord recalls.
Sure, but sorry, but even the one about persons unknown isn't about your clients. Apart from anything else, your clients aren't persons unknown.
No, of course.
The reason it's persons unknown is precisely because serving it on your clients doesn't achieve anything.
Well, it does
Subject
because...
to this case, perhaps.
It does because...
Aren't they the equivalent of the bank in a freezing order case?
Well,
That's what this case is about.
Well, it's difficult and dangerous sometimes to adopt analogies from the analog world, but it could be. It could be. The point I would make is there is a remedy. It is freezing order and disclosure relief. Once a freezing order is issued, and my Lord Justice Birss's point, not issued against my clients in that case,
No.
they would nevertheless have notice of that. And anybody, as we know, who has notice of a freezing order and acts either directly or indirectly in its breach would be potentially punishable by the court. So it has that effect. Now,
Well, I think that's what I meant, because I said
Yes.
served on your clients. I'm not
Indeed.
suggesting that your clients are the defendants, but...
Indeed. And I hope, my Lord Justice Birss, that answers my point. I accept entirely the premise you put to me, but the existence of that freezing order gives you, it holds the ring. The point is it holds the ring whilst you investigate the claim. Now, our point here...
Sorry, Mr. Rand, I'm really sorry. I know I keep... I want to be clear to understand if it's your case that your clients accept that if they were given notice of a freezing order, then a transaction of the kind we're talking about would be something that they would be liable for in breach of that freezing order. Because I didn't think you did.
Well,
I'm surprised to hear you do that, but it's your case, and I'm not telling you.
No. My case is that my clients are not required to do anything. If my clients received a freezing order in relation to this wallet, they would do exactly what they've done for the last 2 years, which is nothing. No one is suggesting my clients have done anything to facilitate either the original hack or the suspension of that Bitcoin in the electronic wallet that can be seen on the blockchain. No one is suggesting they were in any way involved in that. So, my Lord, entirely consistent with my case, I say that the service of a freezing order, it wouldn't have been a matter of indifference to them, but they would not have taken any steps to do anything with that Bitcoin. Their case is, without applying the patch to the whole system, they couldn't anyhow. And I'll come to that in just a moment as a necessary reset. So, with respect, it is consistent with our case. And that relief is important relief. Because when one looks at ground one, the fundamental premise is this is a case of existential importance. Because without the relief, there is no relief. That is fundamentally incorrect. And it is a mystery to us why TTL did not seek urgent interim relief when the hack occurred, as so many victims or alleged victims of misappropriated crypto assets have done successfully before the courts here in London and in the rest of the common law world, Singapore, Cayman Islands amongst them.
But just in case I'm misunderstanding, your client's position is that if they got that order and you had notice of that order, and there was then a transaction taking the money out of that account, your clients are not going to do anything about that. They will sit and watch that happen.
Because at that point they would be doing nothing to facilitate that breach.
Okay. I understand, as it were, that you say the justifications for it, but I want to understand. The point is that your clients would stand and watch as the money went out of that account. Yes. Yes, and I want to be entirely... You say that's because they can't do anything unless they did something extra, which is what this case is all about. Exactly, which is what this case is all about.
So all that means is, it doesn't mean the remedy is ineffective, it just means that one party who would be served with it would not in the circumstances feel inclined to act as policemen to stop a breach. And that's where the developers are in a very different position from a bank. Lord Justice Lewison's point to me a little earlier. A very different position, for reasons we'll come to tomorrow. An obviously different position. So I think that the candid answer to my Lord's question is no, they wouldn't. Because they're in an obligation to. But they would not be facilitating a breach of a freezing. And that does not, in our submission, in any way undermine the effectiveness of that relief. The further point, which goes to the existence of fiduciary duties, and which was a surprising point made today, and I want it to be at the forefront of our minds, it is this, that in addressing the criticism of the judge to the effect that if you cease to act as a developer, your liability comes to an end. In other words, you don't have an indeterminate liability for all time. Mr. Wardale said this: if you leave that role, that is what he calls a core developer, before the breach of duty, then you can't be brought back and you would have no liability. And there were various analogies made, very conventional analogies with trustees. And my lords, we say that that simply does not work for the very obvious reason that there is no mechanism for the appointment of these developers, and there is equally no mechanism for their discharge from that appointment. And objectively assessed, that must be a highly significant reason that militates against the imposition of fiduciary duties, because objectively assessed, why would they take the risk of assuming the indeterminate and never-ending liability? And I draw attention, it's worth looking at this, to the way the claimant put that as a matter of fact before the judge, and still does. And they are facts that can be assumed for the purpose of my Lord's determination. And we see that in the Supplemental Appeal Bundle, tab 2, at page 14. This is, as the top right-hand notation indicates, the first witness statement of Mr. Kane on behalf of TTL. And in this statement, he has listed by name each of the defendants as they then stood, and then provided a short commentary on their status as alleged core developers. And we can test Mr. Wardell's reassurance, and therefore the objectively ascertained reasonableness of what he says, by reference to paragraphs 57.12 and 57.13. 57.12 addresses the 12th defendant, Greg Maxwell. And it's said in terms, he's not understood presently to be a core maintainer, the whole premise for continuing liability. However, he previously was. And then the justification for suing him appears in the last sentence Dr Wright believes that Mr Maxwell still has considerable influence over the development of BTC, even if he's understood to be no longer a core maintainer. And then, if we look below to Eric Lombroso, again, same status, and what is relied upon is his Twitter feed. Now, that is the claimant's case on the facts, which for present purposes the court is asked to accept as the assumed factual basis. The reassurance Mr Wardell sought to give you, which was important in meeting a key criticism of the judge, just does not work. That brings me, by way of this quick overview and reset, to the question of the patch. And my Lord Justice Lewison asked Mr Wardell whether the fix, the patch, could be something essentially between the developers and TTL. And the answer was, at that stage, well, yes, although that, again, that position shifted a little this afternoon. It's by way of criticism, it's an observation. We say the court must bear in mind that the way this technology works is that you can't produce, as it were, a private bespoke solution.
The judge seemed to think you could.
No, it would resolve TTL's problem, yes, but it is nevertheless a patch that would have to be applied to the system, each of the systems transacting Bitcoin with which we're concerned, BTC system, etc. So, and that is what engaged the debate in front of the judge, and from which there is no resiling by TTL before my lords. One of the issues is whether the patch, once applied, would be adopted by all the rest of the system users, the miners and the node operators, or whether it wouldn't. Because if it wouldn't, it would result in a fork, and it would not be effective. That's the argument. Now, TTL says, and they ask you to assume, that it would be accepted because there is an overwhelming commercial imperative for operators of nodes to adopt changes in software, because if they don't, they will find themselves commercially marginalized in the system and stop earning money from operating their nodes. That's the argument. But the premise that this could all be done without affecting anybody else is not TTL's case. It's not the assumed fact you're being asked to accept. The assumed fact is that the whole system has to adopt the patch. The system runs on consent. That's the whole principle underlying the blockchain technology, which is essentially a self-certification by consent. And it would apply, therefore, throughout the system.
I think we better show us that tomorrow morning.
Well, we'll come to that tomorrow morning. Can I deal briefly, in the time remaining this evening?
I think you've run out of time, to be honest, this afternoon. We normally rise at 4:15.
Of course. Well, my lord, in which case I'll address the ground 6 amendment point very briefly in the morning.
Thank you.
Thank you very much.
10:30 tomorrow.